case on this morning's docket. That is case number 102662, Adam Simmons v. Richard W. Porter and Sarah M. Porter, DBA Porter Farms.
Good morning, Your Honors. My name is Jeffrey Jones. I represent the plaintiff appellant, Adam Simmons, and I would like to reserve 2 minutes of my time for rebuttal, Your Honor.
2 minutes is granted.
Thank you. In this case, which is a personal injury case, there are two broad issues that we've raised. First of these is our proposition that the doctrine of assumption of risk should be abolished in Kansas. That is a purely legal issue. It's not dependent on anything unique about the facts of this case other than this is an employee-employer case, which is the only kind of case that doctrine applies to. The second issue we've raised in this case is that the summary judgment, which was granted to the defendant, was improper because there are genuine issues of material fact on the issues of assumption of risk, which was the basis for that judgment. I'd like to discuss that second issue first, because at least as of right now, as we stand here today, assumption of risk is still the law in Kansas. I hope by the time this court renders its decision, it won't be the law in Kansas anymore, but because as of today it is, I think it's important that we discuss the facts of this case and how the traditional principles of assumption of risk apply to those facts and how there are issues of fact that should be tried to a jury rather than summary judgment being granted.
Let me ask you about that right off the bat. Does that letter from the mechanic that you attached to the summary judgment response that you filed play any role in your belief that there are controverted facts?
Yes and no. By agreement between counsel and with the consent and approval of the district court, discovery in this case was limited to the issue of assumption of risk. It's a complex case. There'd be lots of doctors and nurses, and Mr. Blumerick and I counseled and decided, because assumption of risk may be something that would bar the case entirely, rather than spending a ton of money and then filing a summary judgment motion on the eve of trial on that limited issue, we'd try to get that out of the way. There was no discovery really done on the issue of negligence. Neither side had designated any experts. We were looking into really the issues that assumption of risk deals with, which is the state of mind oftentimes of the plaintiff themselves and their appreciation of the special danger that was posed to them. But when the summary judgment motion was filed, there was an argument in there that, well, there's no proof of negligence in this case. So I guess you'd say out of an abundance of caution, we submitted a report from an expert that simply said there is negligence here on the part of the defendants, and the specific act of negligence was providing the wrong kind of tool, in specific a work light that shouldn't be used around flammable liquids.
Didn't the case management order give you a deadline to disclose any experts that you had on the liability question or on the assumption of risk question prior to the date that you produced it?
Well, I guess we used the standard form as far as setting out all kinds of deadlines for complete. There's also something in there that says discovery will be completed by thus and such a date. But again, the theory was that would only be discovery on assumption of risk. And quite frankly, I don't think he was trying to woodshed me or anything. Mr. Blumerick and I discussed, do we need experts for assumption of risk? And I don't think either one of us really thought we did. At that stage, we weren't developing the issues of negligence, not in a broad sense, because we both recognized there wasn't going to be any summary judgment on a theory of negligence. That was going to be a battle between experts.
Well,
ultimately.
One of the principles of assumption of risk that goes through at least some of the case law, and I kind of emphasize some of the case law here, is that in order to be entitled to raise assumption of risk, the employer has to be free of negligence. So it would seem to me that the employer's negligence would be a relevant issue in that stage of discovery that you guys were doing leading up to the summary judgment motion. And if that's the case, it seems like you were late coming to the party with an expert witness on the negligence of the employer. And I guess I need you to address that, because if we get into the detail here and try to decide whether there are facts that are controverted, the propriety of the facts that you bring forward within the confines of the discovery orders are going to come into play.
I see where you're coming from, and you're right. There is case law that says the employer must be free from negligence. But in a sense, I guess, again, having never dealt, I don't think either of us had ever dealt with an assumption of risk case, and trying to figure out how do we frame that limited issue to let the trial court decide it, so we don't spend a ton of time and money on discovery on issues that aren't directly related to assumption of risk. We just went in there, I guess, with the assumption that there would certainly be evidence of negligence in this case, and that there would be expert testimony. Neither one of us developed designated any experts, took any depositions of experts, and I would hope that if that was kind of a stumbling point, that we'd be given the chance to develop that evidence, given that it wasn't a matter of they designated experts and we didn't.
Well, you obviously felt like you needed it by the time you were responding to the summary judgment motion, but let's do this. Let's take off the table the opinions of your expert from that letter. Let's just assume that that isn't proper. With that off the table, make for me the case that the employer has negligence. And so therefore the doctrine of assumption of risk wouldn't apply, assuming we could keep it.
Well, as I say, I guess this is an area where I think you probably do need an expert. I don't think the common knowledge of a layperson is sufficient to know what the standards of minimum safety are when you're operating in auto mechanics. I'll be honest with you, I didn't know there was a different kind of work light that should be used if you're working around gasoline. But and frankly, the evidence shows Mr. Simmons didn't know that. But someone who is an expert does know that. And like I said, I think everyone went into this, when I say everyone, the parties went into this believing we didn't need experts. Then the way the summary judgment motion was framed, I decided maybe it'd be a smart idea to at least reveal the basic opinion that our experts were going to proceed on, which was the work light, was the negligent act, and it was the proximate cause of the fire that occurred.
And looking at that, would you agree that the uncontroverted facts are that Mr. Simmons had superior knowledge of that than the Porters?
I don't agree that is what the evidence really shows.
Okay, and then what is that evidence?
Well, Mr. Simmons was specifically asked, are there any other employees who know as much or more than you do there? And he said, no, I think I knew as much as the other mechanics that worked there. Well, those other mechanics are co-employees. They're not the employer. The employer owed him a duty of care. And that employer's duty of care is established and imposed by the law. It's not dependent on what some random employee knew or didn't know.
I'm asking about the knowledge of the employer.
Again, the law requires the employer to have a certain minimum level of knowledge. If they didn't have that minimum level of knowledge, they were negligent in the way they operated their business.
And where are the facts that would establish what that minimum level of knowledge is for that employer? What are those facts?
Again, the facts would be the expert report, which says that the minimum requirement if you're going to have someone working around gasoline and they're going to be using a work light to illuminate their work area, it has to be this fluorescent bulb, fully encased work light, not your incandescent bulb in a wire cage, for safety reasons. And again, the defendants were obligated by law to have that knowledge. Whether they didn't have that knowledge or whether they simply didn't follow the rules that the law imposed upon them as far as their standard of care, it's negligence either way you look at it.
Mr. Jones, let me ask you a question. Since you have now gone back to this your expert, the agreement you made as far as the submission to the court on the assumption of risk, the decision would be made on submitted depositions, correct?
That's correct.
And this so-called expert was never deposed.
No, he was not.
And as far as your argument about negligence on the part of the employer, your client, who was the mechanic, he didn't even know, as you have conceded, he didn't even know that there was this cool lamp on the market. Is that correct?
At least he didn't say that that's something he should have been given. So the inference would be he must not have known that that was an alternative to the kind of light he was provided.
And he is the mechanic, but yet you're advocating that the employer, who's not the mechanic, should have known about the cool lamp.
Well, he was one of 3 mechanics that worked for Porter Farms, not the mechanic. He was one of 3. Porter Farms employed 3 separate mechanics to repair their own machinery and their equipment. They did so because that would be cheaper than sending that equipment out to a third party and paying them to do it. So there was a profit motive, obviously, behind Porter Farms doing their own mechanic work. If they're going to engage in that kind of work, the employer has a duty to provide a safe workplace. The law is clear. That is a non-delegable duty. They cannot rely on their employees to tell them what their duty is. The employee has a right to assume that the employer is abiding by the legal duty of care to provide a safe workplace and suitable tools unless the employee has actual knowledge to the contrary. And the uncontroverted facts in this case are Mr. Simmons did not have actual knowledge to the contrary. So again, the defendants are trying to somehow cast the burden of complying with safety onto their own employees rather than saying that burden is ours, we will meet it, and we will use our resources. I mean, there are plenty of people. I mean, quite frankly, they try to project Adam Simmons as some kind of expert in auto mechanics, but I think if the situation were Adam wasn't the plaintiff in this case, he was our designated expert, you'd be hearing Mr. Blumerick saying, there's a lack of foundation here. This guy has no degree from his VOTEC in auto mechanics. He's only worked a year or so. Before coming to work for Porter Farms, he'd only worked in auto mechanics for a year and a half. This guy's no expert. And yet that's what they're trying to basically say is, well, Adam was the expert. He should have told us what he needed. Well, not only did they never ask him to tell them what tools do we need different than what we have, the uncontroverted evidence was when he was asked, did you ever ask? Did you just proactively go ask for any different tools? He kind of laughed and said it was common knowledge around Porter Farms. They weren't going to spend any money buying new tools for us. We were supposed to use what we had.
Well, but you argue that the shop light is the defective or unsuitable tool. Is that correct?
That's correct, Your Honor.
Now, if you isolate the shop light, in and of itself, it was not defective. You would agree?
For the purposes it's intended, it was not defective. As far as there was nothing broken about it. But the statements of the law are replete in our cases that say you're supposed to give a safe workplace, which includes safe, which I construe as non-defective, not broken, tools, and also suitable tools, because that work light, while not broken in any way, shape, or form, was so unsuitable that it was unreasonably dangerous put to the use it was, which makes it negligence, even though in and of itself, you're right, there was nothing defective per se about the light. It was nevertheless negligence to provide it under these circumstances.
And what are the facts that support that it was negligence to have that trouble light with the incandescent bulb in that workshop, besides your expert report? What are the facts that show that that's negligence?
Well, I guess, you could say if you're given two choices, if you knew about them and you were said, here's this work light, it's an incandescent bulb inside a cage. And here's this work light, it's a little fluorescent bulb inside a fully encased plastic housing. Which one would you rather use if you're going to be around gasoline? I think, anybody in their right mind would say, I think I'll take the plastic one that doesn't get hot rather than this one over here.
Did the porters testify that they had any knowledge about these cool trouble lights versus the incandescent bulb one?
No, but again, the defendant can't get off their duty of care simply by saying we didn't know about it. That would be an admission of negligence on their part.
And see, I think the problem you've got, or at least the problem you've got with me on that point, is that the law's pretty clear that the employer's not an insurer of what may happen to the employee in these circumstances. I mean, you got to remember, we're in an odd set of circumstances anyway. Workers' comp doesn't apply. This is, and in fact, it's an agricultural thing, which you can argue that's even a different part of the law. So we've got to have some facts that show negligence. We can't just presume negligence because a bad thing happened to Mr. Simmons. And that's what I'm trying to get at. If you wipe that expert letter off the table, what else is there that would show that you have a case of negligence against the employer?
Well, that would be the main thing. And again, our position is discovery. If this case had come before you ready for trial, discovery totally complete, and we had just neglected to develop evidence on a point, I would understand you saying you had your chance and you didn't develop the evidence you needed. But again, this is a weird case. I mean, in terms of being an assumption of risk, they just don't come along every day. I think it's been nearly 20 years since one came before this court. We tried to
this is unfair. This is unfair. You got about 50 seconds left to tell us why we should not follow our case law on assumption of risk, and I'd like to at least hear a summary of why you believe that should occur now.
Okay, Judge, I will be happy to go over that. The reason, I think, is simply because assumption of risk is basically an old doctrine. It grew up side by side next to what I would call its ugly twin sister, contributory negligence. The two, well, we got law professors and treatise writers that like to wax eloquent on the distinction between those two doctrines, but when you get right down to it, the language sounds an awful lot the same. Judges have often intertwined and intermingled that language, and certainly juries, I think, have a real hard time separating those two concepts. I think what you have now with comparative fault, we run the risk that assumption of risk essentially turns into contributory negligence.
What's different now than 20 years ago when we dealt with this?
Well, one major difference is 20 years ago when this court, actually it was more like 30 years ago, I think in the Jackson case was the last time that the court specifically addressed the question of should comparative fault lead to the abolishment of assumption of risk. At that time, the court correctly stated that the majority of courts in this country still follow assumption of risk. In that 30 years, that pendulum has not only swung to where the majority have rejected assumption of risk, all but a handful have. And almost universally, they have said that assumption of risk and comparative fault are incompatible. and particularly in Kansas, where we now have only employee who are not subject to work comp. We're talking about a tiny sliver of the negligence pie that assumption of risk applies to. Everything else, comparative fault does a great job. I see no reason why employers in today's modern society, where you've got risk managers and OSHA and all the things you didn't also have way back when assumption of risk came into being, why employers should not be held to the same standards and their conduct and the plaintiff's conduct judged by the same standards as any other plaintiff and defendant in a negligence case.
But what do we do? This is what's bugged me about this. What do we do with the fact that the legislature has continued to keep assumption of risk in its list of affirmative defenses in Chapter 60 cases?
Well, it also has contributory negligence in that list. Most of that list.
So we got a statute that says we don't pay attention to contributory negligence, but
they
continue to list assumption of risk, and that's been one of the justifications that this court has used for clinging to assumption of risk. So what do we do with that? Do we just ignore it?
Well, no, Your Honor. I think that is the only place in the Kansas statutes where those words appear. Assumption of risk is a common law doctrine. And having been created by the courts, it seems to me to follow logically that it can be abolished by the courts. And if it is abolished by this court, I'm pretty certain that in short order the legislature would remove assumption of risk from that list. I don't think that simply the way for the legislature to abolish assumption of risk wouldn't be simply to remove it from that list. They didn't create it. They simply said it is an affirmative defense. And it is something the defendant must plead and prove, which, not to go too far beyond my time, but that is something the court should take into consideration when looking at this summary judgment. This was a summary judgment on an affirmative defense where the defendant bore the burden of proof. That's almost like granting summary judgment to the plaintiff on negligence. It should be looked at very skeptically by the court.
Counsel, what would be your best analogy for our doing what you've requested, and that is for us to say we don't care that the legislature has put in the statute that assumption of risk exists in Kansas? We're abolishing that.
Well, again, I think the legislature simply put it in there.
No, I'm asking what's your best analogy? Is there some line of cases where we've done something similar to that?
Where the court has done something similar to that?
Yes, what you're asking us to do today. Besides determining that a statute is unconstitutional, do you have an example where we have said, that's just wrong, legislature, take it out?
I think the legislature, again, hasn't defined assumption of risk or hasn't put its stamp of approval on assumption of risk. It has simply said that along with things like estoppel and comparative fault and contributory negligence and all the other things in that list, latches, license, I forget all the things that are in there, it doesn't define most of those terms. It didn't create most of those concepts.
The statute's excuse me, counsel, the statute's just stating when they must be raised, isn't it?
That's exactly right. It's
just
a procedural statute only. It simply says you must put these in your answer if you're going to rely on them.
Is there an analogy to be drawn between this case and your position in this case and our case on products liability from a couple of years ago, where we said we have a Products Liability Act, but it doesn't govern the common law causes of action?
Well, right, and the Products Liability Act is obviously far more extensive in its procedures than simply saying, here's a laundry list of things the defendant must put in his answer if he's going to rely on any of these defenses. I mean, so I think it's a much easier leap to say we can abolish a common law doctrine notwithstanding that it's mentioned in a pleading statute, versus we can create common law that augments a Product Liability Act of the legislature.
Or that the common law continues to survive its passage. That was really the heart of it. Okay, thank you.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court, I'm Craig C. Bloomrick. I'd like to respond to some of the questions, but before I do that, I'd like to say that my position is that Judge Fowler in the district court and the Court of Appeals in a decision authored by Judge Lieben got it right. I would be the first to admit that this was a difficult area of the law for me. This was the first assumption of risk case that I'd actually handled, and I was surprised as I got into it how much case law there is. But I guess from my standpoint, weaving it back all the way to the Lively decision, Justice Ness, you asked about the legislative intent. Back in Lively, this court said that it was legislatively approved. Justice Byers correct, it's a common law doctrine, but it was approved by the legislature. And then in Jackson, which was 1984, and Tooley in 1992, this court again said, in addition to other reasons why assumption of risk should continue to be a viable doctrine, the legislature has had plenty of opportunity to take it out, and they didn't. So I'd like to.
Can you address what we were just talking about, which is what it's somewhat of an anomaly in the statute. It's a pleading statute.
It is.
It doesn't really reaffirm the doctrine or the application of the doctrine in any way.
It does not, and I think Justice Moritz, it's just one more piece of evidence. I think one more thing that goes toward the argument that this court historically has supported assumption of risk, and it's not a legislatively created thing, but clearly I think it is true that if the legislature adopted the arguments that were presented to the court in Jackson and in Tooley, and about all the courts that are retreating from assumption of risk, they had the opportunity to amend the statute. They added res judicata. They didn't tinker with anything else. But I can't in good conscience say that should be the reason for your decision. It's part of the reason for the decision. And I think this court historically, legislative intent's very important. So
what's the underlying rationale for having assumption of risk, which doesn't dovetail very well with comparative fault? Would you agree with that?
I would agree with it. And
what's the rationale for having retaining that concept in the very narrow circumstance of employer-employee relationships and not in other areas?
Well, let me answer it a different way. And I think that's part of the reason I would say that we shouldn't blindly follow other states that are changing it. It's this court that's restricted it. We made the decision in Kansas through the Supreme Court not to extend assumption of risk to everyday activities. In the newspaper last week, Slugger at the Royals game threw a hot dog, hit a gentleman, detached a retina in his eye. In assumption of risk, the Court of Appeals for the Western District had to wrestle with the issue of, is that assumption of risk that bars the claim? The district court said, yes, it does. If you go to a game, you've got a risk of being hit by a hot dog. The court said, well, maybe it's being hit by a baseball, not a hot dog. But in Kansas, we don't do that. I've personally had a case. Young man, a freshman in Council Grove, went out for football and got speared when he was practicing. He wasn't even 100 pounds and lost a spleen. And there's issues of, if you play football, you're going to get certain injuries. But we can't make that argument in Kansas. The only argument you can make in Kansas is he was negligent for going out for football. Now, in Morris County, that's not an argument.
I understand all
I'm
that.
sorry.
What I'm asking is there any good, solid reason or rationale or public policy for retaining it only in the employer-employee and not having it in the circumstances that you've just described?
I apologize, Justice Johnson. I don't know. I don't think there's a good public policy argument for it, other than I think employee-employer relationships are so important in Kansas. And I think agricultural, without workers' compensation to protect farmers. I think assumption of risk protects them from myriad lawsuits that could be brought up over and over and over again. I got my hand smashed in the wagon. Could we have had something safer? Were you negligent in allowing that? I think what we've done is provide farmers with some modicum of protection that if you're a farm worker, you've got to assume some of these ordinary risks, particularly when you know what they are. And consent to being injured, I think, maybe is the reason. But
we have a statutory inconsistency in 6258A where it says that we're going to apply comparative fault in all Chapter 60 cases, and this is a Chapter 60 case. And so frankly, getting hung up with 6208, which happens to list assumption of risk, and as counsel says, it also lists contributory negligence, sort of gets away from what is a stronger directive from the legislature that just says apply comparative fault in negligence cases, and we're done.
I would agree, Justice Biles. I think the statute is not a model of clarity in that respect, but I think the statute is clear that it's intended to replace contributory negligence. So I think that part of it is clear, but as far as Chapter 60 actions, I would agree. Let me go back then to why I think Judge Fowler, who started with this case, and it's an unusual case for me anyway, in that I got the benefit, as did Mr. Jones, of his reasoning. We briefed the case, we argued it, he read all the cases and announced his decision from the bench and explained why he got there. And one of the things he said is, I'm not really a fan of assumption of risk. I don't particularly like it. And I would think, again, Mr. Simmons, we all feel terrible about his injury, but what he was wrestling with is, I look at the cases that have been decided, particularly in the agricultural area, and this is that case, if not stronger. I would say the deposition testimony, and you've got the record, Mr. Simmons did say he had superior knowledge to anyone at Porter Farms. And that part is, the evidence is, they hired him to be the mechanic to fix trucks because he told them he knew how to fix trucks. He had removed 3 or 4 fuel tanks before. That's uncontroverted in the record. So this is a situation where, after the fact, Justice Biles, the first I heard of Mr. Stevie from the defendant's standpoint was when we received the response to summary judgment.
And you agree with what is my reading of the record, is that you guys had a case management order. It bifurcated out liability, and it told you what dates you had to produce expert witnesses on the liability issue, and nobody produced.
We did, and that there is an order. It's in the record, right. And I didn't get an expert. Our feeling was,
and neither did plaintiff.
No,
until you filed your motion for summary judgment, and then this letter showed up.
Right. There was never, and we raised that in our response or our supplemental brief, is that there was never a designation of an expert.
Counsel, was there a further bifurcation by agreement between you and your opposing counsel, however, on what you were going to conduct discovery on and the limited nature of the proceedings leading to summary judgment?
Yes. I mean, we talked about...
So you don't have any disagreement with your opposing counsel's representations about how you agreed to proceed?
No. It's just that it did not come up until after the summary judgment motion was briefed. It was outside of the discovery period.
I understand. Okay.
So again, Judge Fowler struggled with it, but found the case law in Kansas supported this. If in an agricultural situation specifically, you have superior or equal knowledge to the employer, then it's not really fair to say, employer, you should be responsible for an injury that arises out of that relationship. There was nothing defective about the tools here, and we talked about that. This wasn't the trouble lamp or the shop light blew up and caused problems and started a fire. He hung the shop light on the rail. He got under the car with a creeper. He chose not to ask anyone else to help him. He decided he was going to drop this fuel tank. In the deposition, he fully admitted, he was very honest about this. I saw it was jerry-rigged. It wasn't the way you would want it to be, but I got my pneumatic wrench out and I started to take it down. I took it down. It shifted. Gasoline splashed over me. I pushed back. I kicked the trouble light. The incandescent bulb fell and then started the fire. We would submit that that's not an unusual risk, that is something, the fact that if you kick an incandescent bulb and it hits gasoline, that's going to cause a fire. And he, again, admitted in his deposition, yes, I know dropping a fuel tank when you don't.
Isn't that all an argument about comparative fault that you just gave?
It could be. It's both. But I guess, Justice Rosen, to me, assumption of risk it's different than just comparative fault, because you could assume the risk of something even if you're not negligent.
By Mr. Simmons engaging in this task, basically he waives or gives up any right to sue his employer for negligence because it's just the nature of that task. He's assuming the risk of that dangerous activity, or what? Is that basically what we have here? Is that by saying, yes, I'm going to fix this fuel tank, I cannot engage in any cause of action against my employer because I'm assuming this risk?
Depending on the facts. Again,
right.
If you had a defective piece of equipment that nobody knew was defective, that, like I said, something exploded underneath it, I'm not sure summary judgment would be appropriate. It might still be, again, and in the Smith versus Massey-Ferguson, if there's not clear evidence in the record to say you knew what the risks were, then it's a jury question. And yes, I would say that would be different. But here, when everything that happened really is something that someone in his position would know, if I do this, this could happen, then yes, I would say you're assuming that risk.
Do I read your argument correctly that you really think the model for deciding this case is that Smith versus Massey-Ferguson case?
I do. And the reason I say that is because it was the first time that they really synthesized. We had a lot of agricultural cases, and the court in that case really read them all together, synthesized the cases, and said, here's where we are on it. In that case, they didn't have an honest plaintiff in a deposition who said, I knew it. I had more knowledge. I'm the mechanic. I knew this was a risk. In that case, he didn't. The plaintiff walked around the machine. There was some issue of fact as to whether or not he did appreciate the danger, and so they tried that.
Yeah, I mean, it had a removed safety shield, and
right.
The employer knew that too. I guess the reason I'm focused on that is because of the principle that's in that Massey-Ferguson case about the employer having to be free of negligence before they're allowed to raise the assumption of risk defense, which is somewhat controversial.
It is. I don't necessarily agree with that, because they certainly cite the Fishburne case and some other cases in there where that statement is made. But in Massey-Ferguson, they also say that assumption of risk is proper if you knowingly encounter a risk caused by another's negligence. So you've got both of those statements in the case. But so I would not agree that you have to be negligent-free to raise assumption of risk if you understand and appreciate the danger.
Why do you need assumption of risk if you haven't committed any negligent acts?
Well, that's correct. You wouldn't. You obviously would not. And so I think a fair reading, there are passages in the Massey-Ferguson case that say that, but then there are other passages that say it applies when the employer has been negligent, even if you may have breached the duty of providing a safe workplace, if you voluntarily assume those risks going forward.
Is it your position that the employer was just absolutely not negligent in this case.
It is, based on what we have now. But I would agree that negligence, Mr. Jones made a comment, and I agree, negligence, if this was just a negligence case, then summary judgment would be much, much more problematic. Because generally, unless everybody knows all the facts and everything's agreed, that's usually a question of fact for a jury. But we didn't get there in that case, or in this case, excuse me. We got testimony that I think uncontrovertedly puts it into the case law on assumption of risk.
You're familiar with Judge Fowler's decision.
Yes.
And you would agree that Judge Fowler, while he found that the evidence showed that the employer did not provide any defective tools, the employer did not provide ideal tools, and he went further, he said, or proper equipment for the specific job.
I would disagree with that. I think Judge Fowler specifically said, I'm not making a determination that there was negligence on the part of
I agree with that.
So I don't think he made that finding saying that there weren't proper or suitable tools. I think he was
confident you read his decision.
Many times.
Okay.
Yeah, and my interpretation of it and being there was not that he was intending to say you didn't have the right equipment. And I think Judge Liebman picked up on this too, was that you could argue there could have been safer tools. But he didn't make that finding saying, as a judge, you breached the duty of care on this.
Well, would you agree, for argument's sake, that there's a difference between providing an ideal tool as opposed to providing a tool that's not proper for the job?
I certainly would say that the standard isn't that you have to produce the perfect tool or the ideal. In negligence in Kansas, you only have to be reasonable. So I do not think that. And to the extent you would characterize a proper tool as, to me, it's a little ambiguous as far as whether is that based on a standard of care? I'm sorry, I guess that's the best I can do with it. But
well, you're familiar with the Fishburne decision.
Yes,
and in
yes.
Fishburne, the court did say that an employer has a duty to provide suitable tools.
Yes, I do. And suitable, as I would interpret suitable, would be reasonable tools. Not perfect tools, but suitable tools. And assumption of risk is applied even when the machinery or the tools that were being used were broken, which is why I guess I go back to Justice Biles saying assumption of risks can still apply if the worker knows, gosh, this machine isn't even working right, but I'm going to go ahead. This auger isn't working right, but I'm going to go ahead and put my hand on it, and I still get injured. But yes, I guess the proposition, I would certainly agree that you have to provide suitable tools. So I would disagree that there's any evidence in this case that there was not. I think given the facts of this case and what Judge Fowler's comments meant to me was you had tools, you could have asked for better tools if you wanted to, but you didn't, and you had more knowledge than anybody, but you still went ahead and did the work. So again, just addressing the issue of should we follow other states' law, I would comment that other states, they're much more expansive on assumption of risk. It applies to so many different aspects of life. And going back to Justice Johnson, I don't know why we've limited to assumption of risk to that other than we may want to protect agricultural people in Kansas because it's so important that employers not spend all their time in courtrooms defending themselves for injuries, but saying, in essence, if I'm a farm laborer and something happens to me that's ordinarily incident in that, then I assume the risk of that. So I believe that's all I have, Your Honors.
Thank you, counsel. Any further questions of counsel? Thank you.
Thank you.
You'd reserve 2 minutes for rebuttal.
Thank you, Your Honors. Just to follow up on a couple points. I'm not sure that arguing that somehow assumption of risk is meant to protect farmers is really a glowing endorsement of that. I think if it was necessary to protect tortfeasors from being held liable when persons are injured, then it ought to apply to everybody. Frankly, the idea that farmers aren't covered by work comp, that's their choice. You can opt into work comp even if you're exempt from it. So I don't think that, the idea that, well, they don't get work comp, well, they don't have to have work comp, but they can get it if they want it. I think the Smith case supports us far more than it supports the defendant in this case. There, the danger was found to be the missing guard. It wasn't the flailing blades of the combine header. It was the fact that the guard was missing. And even though the plaintiff in that case admitted he knew the guard was missing, he said, I didn't understand the danger that posed. Well, here, Mr. Simmons didn't even know there was a different kind of light that should have been used and that would have made this job safer, and that at least at this stage of the proceedings, he's entitled to the inference that the incandescent bulb started the fire, the fluorescent type of bulb would not have started a fire. That's the whole purpose behind it, is not to provide an ignition source for a flammable substance such as gasoline. So much as this court ruled in Smith that there was an issue of fact on negligence and the knowledge and appreciation of the danger by the plaintiff, the same result should follow here. Lastly, I'd simply say this idea that we get stuck on equal or greater knowledge versus defendant and plaintiff. The defendant had a duty to have a certain level of knowledge. It couldn't say, my duty is limited by what Mr. Simmons knew or didn't know. It had a legal duty to meet minimum standards of care, and it didn't do it.
Mr. Jones, I'm having a problem with that argument. Here's why. Because what you're advocating, I'd like to hear your response, but what you're advocating boils down to this. You're asking this court to tell employers in Kansas that henceforth employers have to keep abreast of new tools, state-of-the-art tools, and provide those tools to their employees, or they run the risk of liability in the case of injury.
Well, I think the phrase you use, state-of-the-art, would be like ideal. And I agree with Mr. Blimerick. The employer's duty is not to provide the ideal tool or the perfect tool or the newest tool or even the best tool, but it is to provide a suitable tool, one that doesn't increase the risk of danger and loss and injury beyond what is reasonable. And here, this isn't the fluorescent bulb inside a plastic case isn't some high-tech, highfalutin, state-of-the-art, cutting-edge, just came up with it yesterday tool. Apparently, it's been around for a while. And again, I think employers do have a duty to keep abreast of what are the minimum safety standards in their industry. And that's all this was.
Excuse me, but you say the cool lamp had been around for a while, but yet the mechanic, the appellant in this case, the mechanic, the evidence shows knew nothing about it.
Well,
is that fair?
And that might be a comparative fault argument, that he should have known just as the defendant should have known. But the defendant had a legal duty to know. It becomes negligence when they fail to abide and follow that legal duty.
Where does that legal duty come from?
It's the minimum.
Not a safety standard. It's not a law. It's not an OSHA regulation. Where does it come from?
Well, we don't know whether it's an OSHA regulation or not, because again, and Mr. Blumick admitted, he and I didn't think we needed experts. We didn't really try to develop the negligence issue. If that was a mistake on our part, I hope it isn't visited upon the plaintiff in this case, because it was a mutual mistake of the parties. Discovery is not complete in this case.
And there's no pretrial order. There's no pretrial order at this point.
No,
The contentions haven't, the final
There was
contentions haven't been developed.
no conception that this case would be ready for trial at the time the summary judgment motion would be presented, because it was going to be limited only to assumption of risk. And the discovery that Mr. Blumerick and I conducted was what we believed was necessary to develop an adequate record for that. If we made a mistake and we needed to develop a better record, I hope you'll send it back and let us do that. Best thing would be to say assumption of risk is no longer the law in Kansas. This is a comparative fault case. Send it back for discovery and trial on negligence.
I'm not certain that I heard an answer to Justice Biles' question. From whence does an employer's duty to maintain a safe workplace arise?
Well, the duty...
Is that a common law
sense,
concept, or...
Oh, well, yeah, the duty in a theoretical concept is a legal duty imposed by law for I think the words the court has used over and over is to provide a reasonably safe place in which to perform his employment duties, which includes reasonably safe facilities and safe and suitable tools. Now, as far as how do we flesh out the parameters of what the employer did or didn't actually do in a given case, there we generally, if it's something the jury can apply through its common knowledge, well, then the jury could apply its own standard. But in most cases, you're going to rely on experts, probably, to explain to a jury, these are the minimum safety standards. This is why this tool was suitable or unsuitable. This is the unreasonable danger that particular tool created. But again, we never got to that stage of this proceeding. Mr. Blumerick nor I envisioned that we'd be arguing negligence to any court in the context of an affirmative defense on assumption of risk. Again, if that's a sticking point with the court that we just don't see evidence of negligence, I'll claim mea culpa. It was my fault. But it was also Mr. Blumerick's fault, I guess you'd say, and to some extent Judge Fowler's fault for allowing us to do limited discovery and present a motion that only addressed a very limited issue.
Except that you thought you needed it because you attached it to your response through the expert witness letter.
Only because of the nature of the arguments that were made in the summary judgment motion, where we had kind of talked with the idea that, well, negligence is just assumed with assumption of risk. We don't need to develop that. We'll just assume there's negligence. And then one of the arguments that was made in the summary judgment is, well, there's no proof of negligence. Huh? Well, I've got experts, but I wasn't... again, neither one of us designated experts or deposed experts. We didn't think it was necessary for that limited issue. But then the way the summary judgment was framed, I felt it incumbent to at least show, yes, we do have experts. There will be evidence of negligence in this case. We're not seeking summary judgment on negligence. He's not seeking summary judgment on a lack of negligence. This is assumption of risk is what we're dealing with here. But to the extent you're arguing that we can't prove negligence, yes, we can. And they have every right to defend against that and designate their own experts and say, that wasn't negligence.
Well, I believe you've already answered this, but just to make it perfectly clear, was there an agreement between you and opposing counsel that there would be no need to depose any experts as far as submission of the matter to Judge Fowler on the question of assumption of risk? There was an agreement that there would be no submission of any deposition regarding experts.
Well, I think we discussed it and we agreed that in our minds we didn't think we needed experts at that point. We put nothing in writing to that effect, but we discussed it and said, I don't think we need to go to the trouble of designating experts and deposing experts, because this isn't going to be a summary judgment between experts. Experts are, their opinions are going to conflict. I think Mr. Blumerick's words to me basically were, I know you're going to have an expert that says my people were negligent, and I'm going to have experts that says they weren't. And we're not going to neither one of us is going to get summary judgment on that ground. So...
It was summary judgment on a legal issue that might have been dispositive. That was the point.
I'm sorry?
It was designed to be a summary judgment on a potentially dispositive legal issue, not on the merits of the case.
Yes, exactly.
Any further questions of council? I see none. Thank you, council.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement. We now